program. So we are very glad and grateful that you found time to join us for our discussion today. The IEA is a public policy think tank, and our mission is to inform decision-making in Kenya through policy innovation, research, and dialogues. The vision of IEA is to work towards a prosperous Kenyan society that has a well-managed economy and that adheres to constitutional principles of governance. So in line with our mission and our vision, we work across 6 broad program areas, and these are, we have the Constitution, Law and Economy program, which works mainly to support the functioning of institutions and also to monitor the performance of key institutions that are established by the Constitution. Then we have the PFM program, which is one of IEA's oldest, if I could say that, program. It carries most of our budget work, and most of our work has been known because of work that is done by the PFM program. We have the Futures and Foresight program, which works on scenarios building and just futures approach to various topical issues in the economy. Then we have the Regulation and Competition Policy program, which of course focuses on regulation. We have international trade and development, and most recently we have work around special projects, which is done by the special program. So today we are here on the invitation or under the convening of the CLE program. And as I've stated, our goal, I work in this program together with my colleague Leo, and our goal as the program is to monitor the performance of key institutions that are created by the Constitution, as well as to apply legal and economic analysis to various policy choices. So that is why we are here. That is the program that has convened us here today. So among the things that we do in line with our program goal and in line with the institutional goal that I've mentioned for the IEA is we've been considering key themes under the Constitution of Kenya, or key important questions arising under the Constitution. And what we've been doing is to create literacy or to have discussions that enhance the public literacy on key issues around the Constitution. We realized that being the main overarching law, it's very important for citizens, for all policy actors to be well aware or appraised of the main things that are provided for under the Constitution. So we've had a couple of discussions on different issues or different freedoms under the Constitution. And today we convene a meeting to discuss separation of powers under the Constitution and its implications for economic development. Why the choice of this topic is that we are all aware that less than 2 weeks ago, the Constitution of Kenya 2010 turned 11 years old. So among the main things that we've seen in those 11 years, we've seen quite a shift from what we had under the old Constitution. And the main, one of the at least progressive things has been the restating or the upholding of the independence. We've seen a bit of developments in terms of the independence of different institutions. But even on the same breath, as much as we've seen some remarkable developments in terms of the place of independent institutions, we've also seen some attempts to sort of claw back or to prevent that independence or that separation of powers. And we thought that it would be important to discuss this because there's a reason why the Constitution emphasizes for the need for separation of powers. I will define what separation of powers means, but I will not go broadly into that discussion because it's basically the bulk of the first presentation that will be done. So, as all of us are aware, separation of powers is a doctrine and a constitutional law, and it basically emphasizes or states that government powers and responsibilities should be assigned distinctly to the three arms of government. So if you look at our constitution, right from Article 1, where we talk about sovereignty, where the constitution talks about sovereignty, we see that the sovereign powers that are borne by, or that are assigned to all Kenyans and all citizens, are then delegated to three institutions, and that is our judiciary, our the executive, and parliament. So right from the Article 1, that is stated as being the main institutions, the three and only institutions under which we have now the separation of powers. And now, because we have a devolved system of government, for the executive, we know that we have both the executive at both levels of government, as well as for parliament, we have parliament at the national level and county assemblies. So the essence of the doctrine is that it provides a system of checks and balances, and just basically prevents abuse of powers by one branch, or a situation where one branch of government has excessive powers. So I will not go into more detail, because again, the rationale for this and probably a more detailed explanation will be provided by our distinguished speakers today. So besides acknowledging that the Constitution provides or demands that separation, and our speakers will tell us about whether separation of powers is synonymous to independent institutions, or what the differences are. In our view, aside from recognizing that separation, we wanted to see, does it have any links to economic development? What economic benefits accrue? Why is it so central for any democratic government? What economic benefits accrue from this separation of powers? Does it have any impact on the functioning of institutions? So those are the main things that we thought we would explore with our discussion here today. And to help us understand the topic, we invited two very distinguished legal experts. These are legal minds who I'm sure most of you have seen quite a bit of their work over the recent past. We have Mr. Waikwa Wanyoike. Waikwa is the litigation director at Open Society Justice Initiative, and he's also a co-founder of Katiba Institute. I'm sure most of you are well aware of the work that Katiba has been doing. Thanks, Waikwa, for agreeing to join us and for availing yourself. Then we have Mr. Seku Owino, who is the head of legal and training at the Nation Media Group Limited. Seku is a practitioner, he's an advocate of the High Court, currently heading legal at Nation Media, and he's also done quite a bit of writing on the place of different institutions, and the one that I've come across mostly is his writings on the independence and the functioning of the judiciary. So both of them are very widely written and are respected legal professionals. And thank you, Seku, for also honoring our invitation. So Waikwa will start by helping us understand the rationale for this constitutional principle of separation of powers. So what we had asked him was to help us understand his views in terms of the in terms of what separation of powers means, basically the rationale, to help us understand the main weak links in advancing this principle, and also his views on the possible areas of reform. And the same separately for Seku, we also asked him to help us understand the link between separation of powers and economic development. Having been a practitioner and worked mainly in the private sector, we thought he'd have important insights on this to help us understand the links to economic development, and also to similarly provide us with his views on the main weak links or in advancing the principle, and as well as possible areas of reform. So then after that, after Seku's presentation, we'll then go into a plenary session, which we will have Kwame Owino. Kwame is the CEO of the Institute of Economic Affairs. He will moderate the plenary session, and basically help us clarify some of the issues that will be arising from the discussion. So that is the program that we have today. And having stated that, I think we'll now go into the conversation. And before I invite the first speaker, I'd just like to restate or remind us of our webinar housekeeping. For purposes of this discussion, because it's being recorded, kindly remember to have your videos and microphones off. I think actually they're already off, but we will allow you to speak and make any question point that you have or ask any question during the plenary session. But as we go along, we invite you to note any questions that you may have in the chat box on this platform, so that we can have the answers and the responses during plenary. So that's it for the introduction. Again, thank you very much for joining this discussion. And I will now invite Mr. Waikwa Wanyweke to help us understand what's the rationale for the principle of separation of powers. Thank you so much. Waikwa, you're welcome.
Thank you, Jacqueline. And just let me know whether I'm audible. Or whether I need to use my earphone before I proceed. I hope I'm audible. At least I'm not hearing any protestation.
Yes, we can hear you. Thank you.
Okay. So thank you again, Jacqueline, and thank you to the Institute for the invitation. I'm also honored to be sharing this session with SECO. He's one person I admire quite a lot. So as Jacqueline said, I'm supposed to help with the discussion on the rationale for constitutional principle on separation of powers. I think I have about 25, 30 minutes to do that, and then there will be interaction later on. What I was proposing to do is to do just three basic things. First, try and problematize the definition of separation of powers. Jacqueline has started us off by giving a definition, and I'll get to that. And then the second area I wanted to speak to is the constitutional rationale, which is largely what I've been assigned to speak to for the separation of powers. And then finally, I want to speak about Kenya Constitution and separation of powers, how it actually works and how it should work. So let's start, I guess, with the definition. Jacqueline talked about separation of power being the assignment of distinct functions to the three arms of government. I'll come to that in a minute. The way I start my definition is by saying that the doctrine requires that the principal institutions of state, that is the executive, legislature, and judiciary, should be clearly divided. And we will talk about why they should be clearly divided, which is partly the distinctiveness that we've heard about. As all of us know, and as all of us, when we have this discussion, where we always start from is the Montesquieu, because he's the one who sort of is accredited on stating in more clear terms, at least initially, the principle or the doctrine of separation of powers. It's interesting when you study Montesquieu because a lot of us and a lot of literature, and especially the legal literature, and by legal literature I mean case law mostly, you find that people tend to attribute the classic separation of power doctrine to Montesquieu. And by classic, and that's my next point, it's important to understand that, first of all, the notion or the doctrine it's quite problematic, even though a lot of us think it's quite a straightforward doctrine, but it's quite problematic. In its sort of straightforward or finest or classic sense, which is what people tend to attribute to Montesquieu, the doctrine has three parts to it. The first part is separation of institutions, which is what we were just talking about, the executive, the legislature, and the judiciary. The second part, or the second component, is separation of functions. So what does each institution do, or what is each institution required to do? And I think all of us would be fairly familiar with what we've attributed, and I would call them cliches, of the various functions of the different institutions. So the executive executes, parliament or legislature makes the law, and judiciary interprets the law. And then the third component is the personnel component, the separation of personnel. So that what this says, or what again is attributable to Montesquieu, because Montesquieu said there would be an end to everything if the same man or the same body were to exercise those three powers. When he talks about the same man, that is the personnel. So the intermixture of personnel, so where you have somebody partly working in the executive and partly working in the legislature. And so in the classic sense, that is not acceptable in the context of separation of power. So those are the three components of the classic or the finest form of separation of powers: institutions, or separation of institutions, separation of functions, and separation of personnel. But in real sense, it's not that straightforward. And so what you find that we ordinarily get is what I would refer to as an impure separation of power. And just backing up a bit, when we think about the pure or the classic separation of power, again, it's very easy to say the best example is the US. So in the US, for example, there's quite clear distinctiveness between the role that their Congress plays, their executive, and their judiciary. And in fact, for legal scholars and legal practitioners, one of the most interesting thing about US is this whole notion of political doctrine, political question doctrine, where even their judiciary is foreclosed from looking at certain issues because they are considered political question doctrine. So when we think about a pure or the classic sense separation of powers, we tend to think American. And when I come to the Kenyan situation, we also tend to simplistically attribute our separation of powers to the American model, just because we've tried under the Constitution to have a presidential system with sort of those clear demarcations. But as I'll be demonstrating, it's actually much more problematic than that. But when we think about the impure, then where there's the intermixture, especially of the personnel, we have to look at England, especially, but there are tons and tons of countries, especially countries practicing parliamentary democracy, and where there is an intermixture between the executive and parliament. And by that I mean a lot of countries where cabinet or members of cabinet, maybe all, sometimes some, are drawn from parliament. So there is not a clear distinction. And I think thinking in the traditional sense, that England presents that model. And going back, and it's hard to have any conversation in Kenya in these days without referring to BBI. There was elements of that were to be introduced through BBI, because they were proposing now to go back to the old model of naming cabinet from, or at least some members of the cabinet from the legislature. But I just want to stay on this impure aspect for a few more minutes and say that part of the reason there is impurity, or part of the reason why it's important to emphasize on impurity is, first, I think Montesquieu, first of all, has been misunderstood. I don't believe, when I look at Montesquieu, that he actually was fully advocating for a classic, clear demarcation model. That's what he seems to point to, but there is more nuancing that is required in understanding Montesquieu, and we'll come to that when we discuss about how problematic it is when we try to place distinct markers in the Kenyan context. But the second reason why it's important to emphasize the concept of impurity is because of contemporary constitutions. So if you look at contemporary constitutions, you find that while they try to adhere to some elements of separation of powers, because of the complexity of the state and the complexity of the issues, it's impossible to achieve the classic model. And I just want to give two examples of how contemporary constitutions are unable to achieve the classic model, and in fact should not achieve the classic model. So the one example is the whole new notion of introduction of the fourth arm of government. And what do we mean by the fourth arm of government? There are two categories that are urged as form the fourth arm of government. The first one, which is familiar to us, is independent offices and commissions, and we have those in our constitution. And when you go to Article 1, for example, there is no reference to independent commissions in the same sense, or offices in the same sense. You see the emphasis on executive, legislature, and judiciary. But when you go to the architecture of the constitution, those institutions sit somewhere outside the arms. So then that complicates the model, especially when you're thinking it in the classic sense. And for those who are interested, Mark Tushnet has just released a book on the fourth arm, and people can read about the different models of fourth arm. But there is a second urging on a fourth arm, not very common, but still there, which is what some constitutions refer, or law or countries refer to, administrative arm. So making a separation between the executive part of the state and the administrative part of the state. And just thinking about it in very simplistic terms, you would think if we were to try and employ that into the Kenyan model, then you would say anything that resembles provincial administration, the county commissioners and all that, anything that goes, for example, to some of the functions traditionally undertaken by administrative tribunals would probably fall within the administrative arm of the state. And then you have the executive arm, which sort of goes more to the cabinet, the policy making, and some of the execution. But that is a very simplistic way of trying to think about how we could interpret it in the Kenyan context. I don't think the administrative arm context applies in Kenya. So that, to me, is how I would discuss the definition of part of separation of powers. But let's look at what then the rationale is. And again, there are cliches here. And the most common is the rationale, or the reason for having separation of powers, is to ensure checks and balances, and to ensure that there is no over-concentration of power on one arm of government. But it's a bit more complex than just over concentration or checks and balances. I want to identify at least three sort of nuanced way of looking at it. So one way of looking at the rationale is obviously the check and balances, the abuse of power, the over-concentration that I've talked about. But the second, which features in Montesquieu, is securing liberty and rule of law. And while you can say the two are related, the first and the second, they are not synonymous. There is a distinction. The second emphasizes on restraining the state, or making sure that the state is restrained for purposes of the individual. The first is trying to demarcate the lines for each of the arms. And then the third way of nuancing it is by looking at it as created to ensure there is efficiency in government. And this is a competency argument. And the competency argument here is that when you actually assign specific functions to specific distinct institutions of the state, which have specific competence, then the government is more efficient. So you don't ask judges to be doing economic work, and as you don't ask economists to do the judges' work. You don't ask politicians who are supposed to develop policy and the laws to be the one going to implement. And we know that that has been problematic, and some of those issues have been litigated because then you meddle so much and you make government inefficient. All in all, at the end of the day, what really matters is, I think, all this, but more importantly, the aspect of checks and balances and enhancement of the rule of law and dispersal of power, especially in the Kenyan context. And I want to go to the Kenyan context and now spend the rest of my remaining time to Kenya Constitution and separation of power. Under this subheading, then I want to discuss or to look at three things. First, what does the Kenyan Constitution provide in regard to separation of powers? Second, what kind of separation of powers is contemplated under the Constitution of Kenya? And then how is it supposed to actually work? On the Kenyan Constitution and what it provides, I want to start by being a bit textual, and Jacqueline started us with Article 1, so I won't repeat that. But I want, before I go to the actual text of the Constitution, I think it's also important, to first of all understand two concepts. Maybe this is where I should have started. The concept or the difference between division and separation of power, because they are relevant. Again, if you go to Article 1, the power that is delegated, it's not just delegated to the executive, judiciary, and parliament, it's also delegated to county government. And so it's important to understand the difference between division and separation of powers, because those two concepts sometimes get confused, and sometimes for good reason, because in certain contexts, they don't mean something different. But in our context, they do mean something different. And what is the distinction? So division, when we are talking about division of power, we are talking about the division of powers between the levels of government. So we are talking about what I call false vertical concept. When we are talking about separation, we are talking about, again, it's a division issue, but it's division of power or functions in a horizontal sense. At one level of government, different institutions of government being allocated different functions. And again, I call that false horizontal. Why do I make this? Why do I say false vertical or false horizontal? In the Kenyan context, especially, people tend to think that when we are talking about levels of government, then you have the national government and the county government. That's not how the Constitution sees it. While you have the levels, yes, the levels actually are supposed to sit constitutionally more horizontal. But for purposes of understanding the concept, it's level. So it's vertical, yes, but it's false. And horizontal, obviously, because again, there is this traditional notion that certain arms of government are more important than others, and so more superior, which again, that is not on when you go to the language of the Constitution, although practically we see it being instrumentalized a lot. So so I just wanted to make that clarification, so that when then we are talking about division of powers in our context, we are talking about powers that we've given to county government and powers that we've given to national government. When we're talking about separation, we're talking about separation either at the level of national government or at the level of county government. And I'll show again how our system is a bit complex when you also try to draw very clear lines on that in the context of division as opposed to even separation. But let's go to the textual. So if we were in the same room, I would have asked the question and asked people to raise their hands. Does our Constitution explicitly talk about separation of powers? We all talk about separation of powers, but does our Constitution explicitly talk about separation of power? And if it doesn't, what does it talk about? And if it does, where does it talk about separation of powers? And interestingly, there is the only time the Constitution talks about separation of powers is in the devolution chapter, and specifically Article 174, when it's providing objects and the objects of devolution. And what it says there at Article 174, the last section of Article 174, is to enhance checks and balances and the separation of powers. These are some of the objects of devolved government. You don't see in the context of national government any indication, explicit indication on separation of powers. Two important points, which people may say splitting hairs, but I think important. First, in the context of values and principles of governance, Article 10, what the Constitution talks about is not separation of powers. It talks about sharing and devolution of power. So sharing of power. So then the question I would have is sharing of power synonymous to separation of powers? And is there any significance to be gained by the fact that there is no explicit expression about separation of powers anywhere the Constitution is dealing with national government, that it only features when you come to the devolved units of government? Is there any significance? But a much more nuanced question. Again, when you go to Article 174, it doesn't talk about separation of powers as being synonymous to checks and balances. Because what Article 174 says, to enhance checks and balances. and the separation of powers. So the Constitution seems to think that checks and balances and separation of powers are not necessarily synonymous. I don't have I don't have much to offer on this. On the questions are posed for a number of reasons. One, these are the kind of questions that you hope scholars engage with. And my concern about Kenya and Kenyan constitution, we actually have what I would refer to as scholarly deficit. If you look at how much writing there is by scholars on the constitution, on very complex concept of the constitution, there is not much. Unfortunately, because of the way we are set up, a lot of our scholars end up spending time writing on consultancies, which is very different from scholarly writing, because that is market, consultancy writing is market driven, as opposed to the ideologically driven scholarly writing. And so we've not had the advantage of nuancing concept. And this was very clear when the arguments were being made on BBI, and especially the question of basic structure. The fact that we fully or largely, almost entirely relied on external scholars to discuss basic structure issues, even though this wasn't necessarily a new concept. We had it introduced in 2000, I think 9 or 10 in the Joya case, and we also had it again in 2013 in a case decided by Lanaola, but very little scholarly, local scholarly writing. And so we were relying on all these external scholars to understand the basic structure. Actually indicts our scholars. Of course, there are good reasons why sometimes our scholars are not able to focus on some of these very pure sort of scholarly discussion, including the fact that we hardly spend on research. But that's important. And this point is also important, even though anyway, it's important for another reason, which I think is fundamental for the development of our constitution. A lot of how we are developing concepts, constitutional concepts, we are doing that initially through quotes without reference materials. And so lawyers, practicing lawyers and judges are the ones sort of trying to develop this concept. And because of that, then we tend sometimes to take very simplistic approach to the concept, as we have with the separation of powers. And this is why. If you look at our case law tends to think that our concept of separation of powers is mostly the classic concept, very straightforward separation and all that, and hardly nuances that, partly because the first time these discussions are being brought at a conceptual level, they are being brought by lawyers who are acting for a side and who are arguing a specific case. And there is no reference materials from scholars. So our leading cases, for example, on separation of powers, that is the TISA case, that is the case on CDF, the Constituency Development Fund. The next case I've seen, which discusses the concept quite a bit, is the Law Society case, this is a case that dealt with the question whether the Judicial Service Act could be amended so that the president is given 3 names, and what that meant in terms of separation of powers, power that is already given to one institution being handed over to the president. There is also the case of the county development boards. A lot of us will remember that I think in 2013 or 2014, they amended the County Government Act to introduce county development board so that senators can be involved in implementation of Executive Functions Act at the counties. And so when you go, and there are quite a number of other cases that reference separation of powers, but there is not much nuancing there, and partly because we don't have much materials developed, reference materials developed in it. So in that sense, then we tend to emphasize the classic model. But, and this is my sort of my last point on the issue of Kenya and separation of power before I come to how it works or how it's supposed to work and finish. Our separation of power doctrine, or the constitutional aspect of separation of power, is actually quite complex, and we still have a lot to unpack. And I'll just give a few examples why. So while I think the Constitution tries to achieve the institutional separation and the personnel separation, where it has significant problems is the functional separation. And not necessarily in a bad way, but just because the Constitution understands how complex things are. So that when you think about the classic model where it says executive only executes, legislative only legislate, and judiciary only interpret, that is not true with the Kenyan model, for example. So just to give an example, executive actually is involved in a lot of lawmaking. In fact, a lot of our day-to-day functional law is not made by parliament, it's made by executive. And the best example is the COVID. The regulations that have been governing the COVID era, those have not been made by parliament, they've been made by the executive, with very little oversight, if any, by parliament. So that is a legitimate employment of executive power, even though there are other problems we can talk about whether it's done correctly. But think also about the president. So we think about parliament again making the laws, and all the president's supposed to do is to assent. But actually the president as an institution of the presidency is also involved in lawmaking. So if you go to Article 115, you find this power of the president refusing to sign a bill that has come to him or her and referring it back to parliament, and the practice has been referring it back to parliament with comments of what he or she would want included or not included in the bill. That is lawmaking. And just again, probably a last example, the judiciary. Judiciary makes rules every day, which again is legislation. If you look at it in the classic sense. And even some of those rules don't even have to be referred to parliament. So while there is the Statutory Instruments Act, which provides the basic minimum when other institutions other than legislature is making laws, what they should do, the reality is a lot of our laws are actually not made in parliament, they are made elsewhere. So that's one of the reasons why ours is quite impure and quite, it's quite problematic to see it in the classic sense. The second reason is obviously the question about the fourth arm, the independent commissions and independent offices. Even though the Supreme Court has said ours is not a fourth arm, in the case of the National Land Commission, it's an advisory opinion of 2014. But in reality, when you look at the architecture, the fourth arms don't sit in the executive, even though Uhuru specifically has really been trying to bring them under the executive. But we have a number of cases now saying that is not what the Constitution contemplates. And they don't sit within the judiciary, where you probably might think they would naturally sit. They sit outside somewhere sort of awkward. So we still have some aspect of the fourth arm. And finally, as an example, is a much more complex concept. So when we talk about separation in the context of levels of government, the division concept, we have national executive, we have county executive, we have national legislature, we have county legislature, but we don't have national judiciary and county judiciary. Judiciary is the same. That also problematizes our concept quite a bit. If you look at other models in other countries, some countries actually do have, again, the separation, full separation, when it comes to the division of all the levels, sides of things. So finally, and I'll take just probably 1 or 2 minutes on this last part, because I'm sure I'm just exceeding my time now. How is it supposed to? And especially when now you think about it not in the classic sense, but in a very complex sense. Just first of all, to indicate that our Constitution actually does try a lot to make sure that there is sufficient infrastructure to demarcate separation. And the Constitution, I believe, has a very good rationale on separation, which, if you look at it from a historical point of view, for me, I think it's to de-emphasize abuse of power and over concentration of power. And so that is what is supposed to be achieved. I think judiciary tends to understand that and has done very well. The executive is hung up on the traditional notion that the executive is the superior arm, and so continues to bully everyone else. Our failing institution when it comes to separation of power is Parliament, which doesn't seem to understand what its place is, how much power it has under the Constitution, and how to leverage that power. And to a large extent then ends up sitting just as an appendage of the executive. And in my own view, if Kenya was to fix Parliament and make Parliament independent the way it is contemplated by the Constitution, we would have fixed a lot of our governance problem. And I hope that we can do that at some point. But it will require a lot, including requiring a very good speaker, especially of the National Assembly. But in the end, what I think the Constitution provides is separation of power, not in your classic sense, not in sort of scholarly sense, but as a higher ideal, which if achieved then would help a lot with our governance. And that higher ideal is to understand, first starts with understanding the complexity, but then comes to the last issue about implementation. Once the various actors, and especially leaders, understand the complexity, then they start working out how they should go about executing their mandate to make sure that they achieve that higher ideal. And where I would leave this in terms of how that could be done is by referencing two authors who've written a book, I think it's a 2016 book, How Democracies Die. And that's Steve Levinsky and Daniel Ziblatt. And what they say is that because of how complex proper separation of powers when executed is, what is mostly required in leadership is honesty and forbearance. So people are willing to be honest about where their lane ends, and people are willing to be forbearing to know that sometimes the lanes are not straight and they will zigzag, and to give way to one institution when it's allowed to zigzag and go into another lane, albeit for a short period of time. And so if we can fully appreciate complexity and exercise forbearance, and obviously get the right leaders who first of all even understands the concept, and secondly are willing to live by the Constitution edict, then I think we'll be fine. Sorry, Jacqueline, I may have gone over by 5 minutes, but that's all I was going to say at this time. Thank you.
Thank you so much, Waikwa. Yes, it was a very insightful presentation. Thank you for taking time to prepare that very detailed and exhaustive presentation. I think a lot of us and all our members and the participants here have greatly benefited from the very detailed presentation. So we appreciate that and thank you. In terms of just a quick summary, Waikwa has defined the concept in great detail. I will not attempt to go into that. He's helped us, he's clarified the rationale for the constitutional separation of powers and helped us understand that it goes beyond the ordinary definition of a system of checks and balances and placed a lot of emphasis. He's placed a lot of emphasis on enhancement of the rule of law. And then he's helped us understand that, I should have mentioned in his definition, he helped us understand that the separation is both in terms of separation of institutions, separation of functions, and separation of personnel. Then he helped us understand the distinction between division and separation of powers, which was also an eye-opener for me, and left us with some important questions which would require a bit of clarification by more scholarly work. In his presentation, it was clear that our model here in Kenya is a bit, it's the impure, we have an impure model, a bit of a departure from the classic definition. And the reasons that he's attributed for this are mainly the reality of overlapping functions. And he's provided some great examples here in terms of looking at lawmaking and regulation, and how, in spite of the fact that Parliament is assigned expressly that function of developing legislation, that's in reality we also have the executive doing this, and especially he's talked about the office of the president, which from the functions that are assigned from the constitution also has a role in making legislation, and separately that even the judiciary in terms of the regulations that they make also have a function there. So we see the overlapping functions and also the discussion around the fourth arm of government, where we have independent institutions and agencies that are created by the Constitution. They do not necessarily fit within any of the three arms of government, but yet they are also not expressly a fourth arm of government. So those are some of the reasons attributed to the fact that the model that we have here in Kenya is an impure one. So I thank you very much, Waikwa. That was a brilliant presentation. And now to go to the second part of this, I will now invite Mr. Seku Owino, who will be discussing, his presentation will focus on the principle of separation of powers and what implications it has, in his view, to economic development. So thank you, and I welcome you, Seku, to make your presentation.
Jackie, can you hear me?
Yes, I can hear you, Seku.
Okay, thank you. I'll just take from where Waikwa has left it, that with that foundation that he sets, basically, I'll just go into a discussion of what, try to explain part of the, how separation of powers under the Kenyan Constitution specifically dovetails into economic development, or was intended to dovetail into economic development. I'll start with the first one, where we say, you know, Kenya is stated to be a republic. This is another interesting one, by the way. The Constitution itself does not say Kenya is a republic, 2010. But when you go to Article 2, it makes reference to the Constitution again. This Constitution is the supreme law of the republic. So by that statement that it's a republic, in contradistinction in constitutional theory terms, you can have different kinds of constitutions. You can have a constitution where there's a republic, You can have a constitution of a country which is a theocracy. So you can hear, for example, Iran is a theocracy, is an Islamic country, or you can have a monarchical constitution like Britain, where it's not a republic. The power divests in a monarch, which then whatever's best. But in Kenya, there's as Waiko was putting it, I'm just trying to put it in terms of some economic concepts. Republican constitutionalism abhors monopolies. That is why then you would have the separation of powers in functions, as we say, institutional separation of powers. That's why you will have the judiciary, you will have the legislature, and you will have the executive. Because if power is accumulated in one person, then the thinking is that it will lead us towards tyranny, and as it often happens. So that the state functions, the state or the republic will function best when decision-making powers are dispersed. Waiko has said that as well. So that effectively, when you look at the law, there'll be one department to make the rules, that is the legislature, though again imperfectly, not entirely clearly separated as is made. Then there's another one that implements them, the executive, and then another that adjudicates on what those rules are within the same constitutional structure. And this, in a sense, mirrors, because you remember, as he said, in terms of the professionalization of it, he says that it mirrors Adam Smith, again in The Wealth of Nations, where he says that the effect of the division of labor, if we can treat those functions as labor, produces efficiency in markets and industry. Therefore, specialization, as we were saying. You do not want a parliamentarian being the one to read the law and interpret it by himself. It needs a specialized person trained specifically for that. We have somebody else in the executive who then makes policy using the bureaucracy that exists for them there. So with that, you get, again, I was going to say that the separation of powers that is in Kenya, as Waiko said, is also both vertical and lateral. That is that within the institutions, as he said, say, within the executive, for example, you will have the national and the county governments, executive. Within the legislature, you will also have them. And in our case, the legislature is even further divided, because we have, even within the national legislature, we have a Senate and a National Assembly, whose functions also in lawmaking are separated somewhat. And then, of course, we have the county assemblies in legislation. And then in the judiciary, yes, we do not have a county judiciary, devolved in that sense, but we have a judiciary which in itself, if you look at it, also has some separation of powers within it in this sense. Take, say, the High Court, where we say whatever. We have within the High Court, and the Constitution permits us to create courts similar in jurisdiction to the High Court, but whose specific remit would be is employment and labor relations matters. So technically speaking, there's a separation of powers within it. So we say we have within the High Court, we have within the courts, the judiciary, courts which also have separated powers to perform different functions within that scope. And so with that understanding, so we have the lateral and we have the vertical understanding of separation of powers. I just want to then jump quickly and to say, how then does this come into what I was asked to do, to think about economic development? There's an understanding, therefore, that everybody, there will be shared responsibilities, there will be different functions that are served to just keep the constitutional rubric standing. This is where, how I look at it, the economic development. And here I am defining it as more than just economic growth, okay? As we would say in increased GDP and other economic matrices. We are saying, yes, economic growth itself is vital, but it is insufficient to ensure development in the wholesome sense. So that I take the definition of Amartya Sen, where he says, development requires social and economic progress in the overall state of the society over time. So it's progress. It is about creating freedom for the citizenry simultaneously with the removal of obstacles of freedom. We will see how the Constitution of Kenya 2010 tried to do this. And the obstacles that you see that are meant to be removed are poverty, corruption, poor governance, lack of education, and poor health conditions. So it's a whole subset that seeks to say that let development be human development, not merely GDP numbers. Okay, and that's the sense in which I will want to look at it. So when we go to that, we come then to here again was a big issue that the Constitution of 2010 tried to solve or tried to introduce in Kenya. There'd been within the law, particularly in Africa, since independence, a very big debate as that we cannot, we have to make a choice, that there was a choice to be made between human rights in the sense of the civil and political rights and economic development. There was a thinking which convinced most of African statesmen, if we can call them that you needed to go easy on civil rights so that we can propel development faster. They're saying, look, we are not going to be able to do these things together. We have to surrender one to be able to do that. And in this sense, they were copying the Asian tigers, in a sense, saying, look, you see, the Malaysias and the Indonesias and the rest of them and the Thailands became, and the Taiwans became what they are because they suspended aggressive pursuit of economic, political and civil rights. So let's go the same way. In Kenya, that seemed to have persuaded some people. That dichotomy existed, that you cannot pursue the two together. But if you look at it in terms of what the Constitution of Kenya brought to us, first, it brought this thinking, in a sense, shredded it. The Constitution of Kenya seems to think that all these rights must be pursued together, and therefore the development that is meant to be done must be economic development together with all the other rights. We want to rid of corruption, we want to get people educated, we want better health outcomes, and we want better governance. It sought to do this in the human rights entitlements. Let's take the example of Article 21. I'll go textual here as whatever. It says that there's a shared obligation, and here is now where separation of powers comes, on the state and all its agencies to observe, protect, promote, and ensure fulfillment of human rights under the Constitution. So it's basically saying, in the separation of powers, yes, powers are separated, but at the same time, on this, we must work together, creating a, so whether you're in the judiciary, whether you are in the legislature, and whether you are in the executive, you have to work to promote and protect and ensure the fulfillment of human rights under the Constitution. And specifically, it goes to Article 43, and it requires the state, that is executive, to institute policy and legislation to enforce the economic and social rights under Article 43. Okay, and if I may just read what these rights are. 43 specifically talks about economic and social rights, the highest possible attainable standard of health, healthcare services, reproductive healthcare, adequate housing, standards of sanitation, the right to be free from hunger for the people, to have adequate food of acceptable quality, clean and safe water, and social security, including the right to an education. And the state is being told, look, institute policy, that is the executive. Parliament is being told, then legislate these so that they can be enforced by the judiciary in the form of specific rights to the individuals. So here again, you can tell back a consciousness on the framers of the Constitution, and within this is not even in spirit, this is actually in its letter and in a strict sense saying, ensure that we achieve economic rights and social rights alongside all the other rights in everything that you do. Okay. So that in this case, with the separation of powers for Parliament and the executive, the Constitution and the human rights chapter creates for them as well an obligation. You don't just have a power that you exercise as you wish. Here you have an obligation to ensure that this is done and that it is achieved. Okay, and if you then come to Articles 22 and 23 then provides for enforcement through the judiciary. 25, non-derogable rights, are a very interesting one. Again, the rights against torture, but look at it: slavery, cruel and inhuman treatment, fair trial. These again are just rights that go towards quality of life beyond just the simple rights that we do. So they're all being put together, and these are rights where you say they're non-derogable. The Constitution says we will not permit any circumstance by which these ones can be curtailed, whatever the case. And therefore, bringing in, just reiterating what I was saying, that it rejects the human rights and economic development dichotomy as false. The Constitution of Kenya seems to be saying, look, we must scale the steps and chew the gum, that as we go towards developing the nation, we make sure that the individual too gets the full development of it. You can't tell him to choose his civil liberties over economic and social rights, basically. And here you can look at the Mitubel judgment in the Supreme Court decision, number 3 of 20. In January this year, they were talking about the right to housing, and they were telling the state, it's not enough for you to tell us. This was a case where some people had been evicted from some land. There were squatters on some land which belonged to the Kenya Airports Authority. Then they've been evicted, and the Supreme Court actually told the state, look, you cannot just evict people from their place and then say that this is not their right to do this. Then they're saying, look, they still have rights within this. If you cannot give them that land to live on, then you have a right to provide for them some adequate housing. So it is not sufficient to simply cop out on this. And where I see this was, again, you know, the Constitution talks about these rights being achieved gradually. Gradually is not meant to be, in this thing, a cop out where you say we can't afford them today. Basically, what this was saying, begin to make efforts and demonstrate that you are doing better today than you did yesterday, and that you're trying to make sure that this progressive achievement of these rights is actually a reality rather than an excuse. And so you see that in the whole of these entitlements, no right, technically speaking, has been given preeminence over the other. In other words, the Constitution is saying, take the Bill of Rights as a go, enforce them, and try to take all the measures that you can to ensure achievement of this. Basically saying that the economic development and the development that we desire is one that is real for every person in the society. Okay. We then go, the next one that I talk about, so in addition to the human rights entitlements that have been brought, there's no dichotomy either. I now go to how the Constitution wants to use public separation of powers to enforce proper public resource utilization for the benefit of the people and for the economy. And the biggest one is that it introduces what we may call, yes, the Supreme Court has held, as Waikwa says, that the National Land Commission is not a fourth arm of government. But whether it is or not, it is a crucial part, and is given some crucial responsibilities within the Constitution. One of them is managing it, empowering it to manage public land, removing it from the traditional executive, as it were, where it was realized that it had all the issues that affected development, corruption, land grabbing, and all those kind of issues, the lack of transparency regarding how land was alienated and given to people. But here, the National Land Commission is empowered to manage public land on behalf of the both national and county governments, and oversight land use planning. So basically saying, look, we want some transparency, we want something that allows people to ensure that land is alienated properly, and that even, for example, where land is to be compulsorily acquired, private land is to be compulsorily acquired, the National Land Commission has been brought to stand in between the executive, which may seek to acquire the land, and the individual or the citizen who may find his land on the line of fire for compulsory acquisition. It is the National Land Commission which is now required now to make the plans, make valuation, and make an offer to ensure that there is fairness in the compensation and that it is done promptly. Part of the issue it sought to to do here was that even within the compensation, there were issues hitherto. One was that either they compensate you unfairly, and even if you are compensated, it's too late and you have nothing. Here now the National Land Commission is told, make sure that we do not hinder the property rights and therefore economic rights of the people and of the larger society and of the larger economy by allowing the executive to run roughshod over the rights of the people. Okay, the judiciary then is allowed that even if after the National Land Commission makes a valuation and you're unhappy with it, you can challenge it. So again, the powers, the separation of powers is meant to come into play here to ensure fairness in this. And basically, in a fair society where the rules are adhered to, economic development goes on and the citizen gets better. But it goes ahead and again seeks to share this power and telling Parliament in Article 68. It required Parliament, recognizing the problems that Kenya has had with land, to legislate land policy. So basically, Parliament was to work with the executive. The executive was to pronounce, propound a land policy, take it to Parliament to look through it and to pass it on. Again, notwithstanding the fact that Parliament sees that this power, it has a power, but it's being compelled that one of the ways in which you must exercise your power is to pass a land policy for the Republic. Of course, for the same reasons, again, recognizing land as an important resource. I have issues there we'll talk about later, but it recognized that land was an important resource for this country, but had considerable problems within it. So the Constitution tries to clean that up by bringing the separation of powers to them, to currency. So where Parliament oversights the land policy that the executive may come up. And then in 69, it again says ensure policies on the environment and requires Parliament to legislate policies, environmental law, and the judiciary to enforce and address environmental abuse, so that in the event that the policy results in abuse or whatever, it's basically providing an opportunity. And here it includes the citizen. You would know, for instance, as a matter of law, you would know as lawyers that one of the biggest problems with enforcement of environmental law prior to this Constitution of 2010 was on the issue of something we called lock and standby. That if, for instance, somebody decided to alienate a forest, bring down Karura forest and cut it into plots and give themselves land, as a private citizen, you had no way in which to do it. Okay. You know, for example, that sometime in the 80s, the late 80s, Wangari Maathai tried to stop the building of Kenya Times Media Trust on Uhuru Park. Uhuru Park would today be a property of 60 floors of KANU headquarters. Okay, yes, she went to court for it. She did not stop it. Somehow, by some fortunate intervening events, it didn't. But the court threw her out and told her, you know, you are a nobody. You do not have a right recognized to stop a public wrong. So this is what Article 69 was trying to address, saying, look, you do not need to be able to prove that that land specifically belongs to you. All you have to do as an individual is to go and say, look, there's a danger to the environment here, and the judiciary will intervene on your behalf if the other arms of government fail to do it or are themselves part of it. We come again to national resource agreements, which have economic benefit for individuals, for people, because minerals, etc., are deemed to be the property of the state. So again, to prevent alienation of private property, and it requires Parliament to ratify all agreements regarding the exploitation of natural resources. So that if, for instance, we were to discover oil and gas and whatever, all these oil exploration, supposing we will get to the point where the prospecting has proven that we have some natural gas somewhere, those arrangements and those agreements cannot be done in some cabinet secretaries or principal secretaries of energy or petroleum in his office, and we are told that this is now confidential or private. They would have to go to Parliament to ratify them. And this again opens it up to ensure again that the country gets the best deal and the details of it are known. You know, again, issues of equity in equalization fund, we know the history about it. Countries that are challenged in terms of equity do not get the proper human development that is required. So then they say, look, the equalization fund is meant to force the state to sanction, to prevent the inequity that the state sanctions, which then militates against development of certain people or certain countries or certain counties within the country. And so it requires equity in public resource utilization. Say in Article 201, it goes ahead to say that the taxation burden must, to the largest extent possible, be equal on all citizens. And by the same token, it also says that the sharing of resources and tax revenues between national and county governments too ought to be fair and equitable. Leading again to us thinking, okay, development is not just about developing Nairobi or certain sectors, but we must think of ourselves as a country so that the development is wholesome. That's the thinking here. The same again, we have an Article 227 that even talks about thinking about equity in procurement of goods and services. Okay. So then it says, try to think nationally whenever you are procuring goods and services for the country. Again, it forces the use of legislative power to try and see what are the considerations we will be looking at in public procurement of goods and services as the criterion, and then allows the judiciary again in the separation of powers that where this is not done, you can actually challenge a procurement process as having been one that does not foster equity in that particular procurement sense. Next slide, please. And then, of course, there's the role of the independent commissions. This we were specifically asked. You know, the Kenya National Human Rights and Equality Commission. It is meant, one of its specific roles is to monitor equity and equality in all spheres of Kenyan life. Okay, so it submits reports to Parliament. It questions the executive. It can question the Director of Public Prosecution and recommend prosecutions for human rights violations. It can question audits, actually, national institutions for compliance with human rights law and legislation. And that's a good one towards, again, ensuring equity. In fact, one of its considerations is that its gender equality consciousness is one of the things that it must look out for in all these things that it is doing. Again, to try and just bring into that development thinking that Amartya Sen defined and led us to as development as being freedom as well. And then it brings in Article 79 on the establishment of legislation, where it orders Parliament pass legislation to establish a body to oversight ethics and integrity, okay, and monitor corruption within government. And in that, by government, it says the whole state and within state bodies and functions. So basically, EACC is established under this to try and do this. Once again, it's meant to improve our governance indices and do this. Again, another one is the SRC, the next independent commission, Salaries and Remuneration Commission, again, an independent one, meant to ensure that there is fairness within the public service in terms of compensation and in terms of use of resources and the financial resources of the country in a sustainable manner again. Okay, it seems to want to say, look, because this constitution is for prosperity, in the preamble we are saying we are setting this up for ourselves and for future generations. It's trying to say, look, let us use the resources we have, whether it's in compensation, in a manner that is fair and equitable, not only for within a given generation, but even intergenerationally, so we do not burden them too much with taxation. And then it establishes the Commission for Revenue Allocation. Again, same thing on equity, somebody to oversight how and make recommendations on how revenue and the resources of this country are shared. Okay, equity again as an important component of true development. Okay, And then, of course, there's the one that I don't need to mention is Parliament and the executive working together on budgets making, which basically is the budget is essentially raising resources and how they are utilized within the country. So the budget policy statement is sent, the two houses look at it and they debate it, a finance bill is passed, and the revenue is raised, taxation is appropriations are done, and what do you call it? Parliament oversights how public resources are used, and in so doing, you think that it would then seek to ensure that all these principles of equity and transparency are injected in the budget process. I agree that this is not done too well, but the constitutional springboard for this being done is raised. And of course, in a country where resources are used equitably and optimally, naturally, the economic development and the true development of all the people is assured. But having said that, so those are the kind of examples but having said that, there are certain weak links that militate against proper economic development. I would say some of the 2 or 3 things that show some wrong-headedness in the way the Constitution was structured, and which we may want to think about. The father for it did not think. They come majorly from our concern with land. And I always say, we had a land commission, which explains our history and our obsession with land. And land is a very, very big corruption. I actually sometimes, there's a joke we normally say, it's not a very good joke, that if you, for some reason, went and jailed everybody in Ardi House, that's where the lands office in Nairobi is, the corruption index in this country would go down easily by 80%. I think that's true. It's an exaggeration, but there's a point there. So it explains why there was this concern about land. So land is probably just about the only resource for which the Constitution has created a specific commission, okay? The National Land Commission. But look at it, some of the troubling things here. It says that under Article 65, it says that the land rights of non-citizens, that if a non-citizen owns land in this country, private land in this country, then he cannot own anything other than a leasehold of 99 years maximum. Okay. So basically, we are saying that we want investors to come here. We want a proper development. But if an investor wants to come, and imagine a situation today where Seku owns land and it's given to me, maybe I need to explain a little bit of law here. Land can be owned in 2 respects, or at least traditionally. You can own land in what we call absolute ownership, where the land belongs to you and yours and complete. Or you can have a leasehold, where the leasehold is the government gives you that lease for a given period. They can give you a 50-year lease, they can give you a 99-year lease, they can give, there are pieces of land in this country where people had 999-year leases, very, very long ones. So basically, it can go from one generation to the other. We are saying that if it is Seku who is to own this piece of land, let's imagine some piece of land in the city, because he's a citizen, he can own a lease of 200 years, or he can own it absolutely. He will never have to give it back to the government. The lease will never expire. But if that same Seku were for some reason to decide to sell it to somebody else who is not a citizen of Kenya, to continue doing the same business in the country, he gets now suddenly a reduction and gets a maximum lease of 99 years. What does that do? It diminutes value, because I don't need to tell you, if you have a lease of 200 years on a piece of 1 acre piece of land, naturally that means something, because when somebody is buying it, then he says, okay, I still have 199 years left on this if it's a 200-year one. Or if it's absolute, he says that I own this land forever. But if you have a lease of land where you have only 99 years, then basically you're telling Seku that that land which was yesterday worth this amount of money has now changed value today just because of a citizen, of the issue of citizenship. I find this, it comes with a lot of economic distortions in terms of the value of land in a country like ours. And worse still, it even says that even where it goes all the way to the shareholding of a company. So even if I own this thing as a company and I admit a shareholder who's a non-citizen, that takes effect immediately. The rationale for it doesn't make sense for me, especially because we are a constitution in the first place which allows, we are not that hostile to foreigners. We are a constitution which allows dual or multiple citizenship. So I don't know what purpose this serves other than an ultra-nationalistic sense of saying foreigners ought not to own land in this country, which is not where we want to go and is not in line with the rest of the principles of this constitution as an open one that respects all of humanity, takes everybody as equal, etc., etc. This, I think, has issues. It's not been litigated, but I think it can have even constitutional questions where we're having conflicts within the constitution that are almost difficult to reconcile. Because you must remember that the right to property in the constitution falls in the Bill of Rights. Then this falls under the National Land Commission and the powers, and you create issues there. But even more important one, an even more difficult one, is again where Parliament is told to work on a policy, on that land policy they were told before, legislate on a maximum and minimum acreage ownership of private land. It's an attempted response to grabbing, but what it doesn't see is that it's unviable as economic policy, or even in reality. What happens? You know, it presupposes that people will always buy land. Land will always. What happens to you if, let's imagine a situation where, and this is a practical one for conveyancers and property lawyers like myself. Let's imagine a situation where you have 100 acres and the limit is stated to be 100 acres. Let's imagine we say, okay, let's say we say 100 acres is the maximum private land anybody can own. Fine. And then your father maybe passes on and you inherit that 100 acres. What do you do with it? Are you going to be forced to sell it? So you can see that it hasn't quite thought through all these things. And that is why this section of the Constitution remains unimplemented. That land policy has not mentioned anything. It just keeps recommending that research will be done on it. But it creates an unnecessary issues because it even says largely private land. How is it going to say? Private land itself can be used for several. There's commercial private land, there's agricultural private land, there's residential private land. So are you going to legislate it and say, okay, when it comes to commercial private land, you cannot own more than 1,000. When it comes to residential, you cannot own more than 50 acres. Just very, very bad economic thinking here. And I think the economists here would even give me a better, would even understand the kind of dilemma this, just outside whatever. But also the thinking about it is that it's got a very agrarian outlook of land as the ultimate form of property. Why haven't we said here, for example, that it goes for equality in a very raw sense? Why haven't we said here that other forms of property? Why aren't we trying to control the acquisition of other forms of property? And therefore, I think this is a very, very ill-thought, maybe well-intended, but ill-thought law, and unfortunately has made its way into the Constitution, that if somebody was to amend the Constitution today, this is one thing I would want us to rethink and relook, because it militates against the very, very economic development and overall economic development that we would want, not just for individuals, but for countries, for the country and the nation as a whole. And so, in conclusion, I am concluding. I hope I haven't taken too much time. I just want to say that on the whole, the Constitution of Kenya, it creates a charter that is conscious on the need to have the shared responsibilities, okay, and the shared and the separation of powers to create shared responsibilities by the different organs, whether the independent constitutions, whether the executive, whether the legislature and the judiciary, to uphold freedom as a component of development, including economic development in the traditional sense. And that therefore, the challenge, as Waikwa rightly said, and as most of us would probably know, is in the way in which we have not amended it. I mean, we have failed to implement it, or the way in which we see it. And there remains a lot, as I rightly say, with the two examples I've given regarding land. There could be several others that I would give if we had time, where we find that, yes, the Constitution may need reform, but separation of powers and the separation as structured in our Constitution, as imperfect as it is, there are certain benefits, including economic benefits, that it would herald for this country if unfurled in the proper way in which it was intended. Thank you.
Thank you very much, Seku, for that very elaborate presentation as well. I think I speak for everyone that it's been beneficial to all of us listening, and you've helped us understand very clearly some of the links between separation of powers and what implications it has to economic development. I know we are running out of time, but just in a minute before I invite Kwame, Seku's presentation started by looking at the essence of separation of powers, where he re-emphasized that it should basically be understood from the context of division of labor. And what does that do? Division of labor produces efficiency in markets and industry, and he defined that very elaborately. He then now went into specifics of looking at the links to economic development, where he defined economic development as being broader, or that it should be understood as being broader than looking at growth rates and other economic matrices, and said that development growth by itself is good, but it's insufficient to ensure development. Then now, in terms of connecting the issue of separation of powers to economic development, he looked at it from the context of human rights entitlements and the different assignment of roles to all the three arms of government towards ensuring that human rights are promoted or advancing and working towards the fulfillment of rights of all citizens, the roles that are assigned to the three arms of government in ensuring the realization of rights, basically. And he gave some examples on what is required under the Bill of Rights. And then he spoke about public resource utilization as being another link between the rationale for separation of powers and the role of different institutions. And here he's spoken elaborately about especially land use and land management, and how different the three institutions, or how separation of powers requires different institutions to ensure equity in management of public resources, and how, again, looking at land as a critical resource towards, in terms of economic development, how the role of different institutions advances that. So thanks a lot, Seku, for that very exhaustive and insightful presentation. And on behalf of the CLE program, we thank both speakers. And now I'd like to invite Kwame to moderate the session, the plenary session. Thank you.
All right. Thank you very much, Jackie. And good morning, good afternoon, everyone. Well, we actually have run out of time, but I hope we can have another 20 minutes just to conclude this discussion. So I've looked at the chat box in here and I haven't seen any questions or part of the discussion. I'd like to just open up to anybody with questions. Please send them, or you can use the floating toolbar to raise your hand, or just alert me to the fact that you have a question, and then I'll ask those questions. So the way we do it is we'll try and ask for 3 questions at a go, try and direct them to whoever is which of the panelists, or if you have general comments, you could make that, and then any of them would respond. So we'll simply have two rounds of questions. So the first one would be basically a couple of questions, and then of course we'll have the second one before our panelists make their closing remarks. As we wait, because I haven't seen any hands up, as we wait, maybe I should hijack the dispensation of the moderator and just make some comments as well. I think I've been educated today partly because Waikwa cautions against taking Montesquieu's argument about separation of powers in an absolute sense. I have to say that my orientation is always to take it in an absolute sense, and then to say that anytime when the pieces fall in the gaps, separation of powers, and especially in the absolute sense, forces a compromise between arms of government. That's the way I've thought about it. Because in addition to, of course, that it achieves certain objectives of law, the primary objectives of law, which is basically checking power. I think that perhaps it's possible that when Montesquieu was writing, I think the absolute reason for need for separation of powers was basically to check the monarchs, who are completely authoritarian in many ways, or absolute monarchs in many ways. So obviously, when you're arguing for the separation of powers, the language and the temperament at that time did not want to give us much space to it. But you're right, that it is not possible for absolute separation, because obviously that in itself could generate dysfunction. But I'd rather have more tension between the arms of government than what you hear more recently. And here is where I come to a question for both Waiko and Seku. We hear quite a lot. I'm very concerned because, I mean, as I hear you lawyers saying that we cannot rape, just take separation of powers and rape it. I'm very concerned because one of the things that happens, rather one of the modern vocabulary that we have as Kenyans is this argument that government should coordinate functions, which you understand, and even within the cabinet itself, there's a coordinator of colleagues, there's a coordinator of things in counties, all coming from the executive. And the language of coordination has gone in to everybody, that I even hear it communicated from the Chief Justice's office that there's need for the executive to coordinate together with the judiciary and other arms of government. And I wonder what constitutional authority anybody has to demand administrative arrangements or coordination of this kind. Because I fear that that's basically one of the ways in which you make one step back, and then we continue as Kenyans to defer absolutely to the executive, which I do not like, so I must state that. So what do people have to say for this language, which we see quite a lot, and almost Kenyans take it as a given, that we have to be conscious about the limits of separation of powers. There's a need for government to coordinate functions and to coordinate in the kind of stuff that we do. We see Parliament demanding that the Chief Justice, for instance, coordinates some functions, or in some of the, or rather it's the reverse, basically Parliament being asked to apply its authority to call for submissions from other arms of government, as is convenient for the other arms of government. So as we wait for questions, because I don't see any coming, I'd like to hear from both of you what you have to say about that question of coordination, and if by being lawyers and very pragmatic, allowing for the fact that absolute separation is not possible, you're putting us on a deliberate slippery slope towards executive capture of state institutions, but also that. So that's the first question. The second question that I mentioned, why this concerns me, is only lawyers and myself, okay, not true, but only lawyers seem to understand something that basic civics education in Kenya does not give us. Kenyans speak about government. You even hear members of parliament appallingly speak about government to mean the executive. And my view about language being important is because it's giving the impression that the constitutional architecture has placed the executive in a privileged position relative to the others. Does that worry you or not, or am I just a paranoid guy sitting in the offices of the IEA and looking for reasons to cause trouble and reading the Constitution selectively to try and state that? So I have other questions. Let me read those. So my first two questions are basically this coordination language, and the second one is the idea that the executive, when people talk government, they mean executive. Let me see if I have other questions on the chat box. Yes. Oh yes. My colleague Leo has another question, and he says, please ask both speakers on how Parliament can reclaim its distinct powers that are separate to avoid decline, well, of Parliament as an institution required to check other institutions. I agree. If you ask yourself which arm of government has used its powers of separation the least, whether it's in budget control and all that, I think Parliament has been the poorest performer. And you see that basically. So what does that, what do you people have, what do you have to take, what do you think, what do you all think is the reason for that? So I'll circle these questions, please. I'd like to limit you each to about three minutes each so that we can come for the second round of questions and then we can conclude. I'll reverse the order of presentations right now, and Seku will go first. Seku, you can please respond to your questions.
Yeah, can you hear me?
Yes, we can. Go ahead.
Okay. This thing of working on coordination without ensuring executive capture, I think everybody just needs to go and be clear about what needs to be coordinated. It's not supposed to be one where people go to surrender their bits and go there. I think my understanding of the Constitution, that it's linked somewhat to the second question where you ask about government synonym with the executive. I agree, it's worrying. That's when you hear somebody sitting in a cabinet secretary, somebody saying the government while speaking in parliament, for example, is clearly worrying that it's either a person, it comes from a point of lack of understanding of the Constitution itself, or a deliberate form to amass or bludgeon out, muscle out the other arms of government, and therefore try to put them in their place as being inferior. It needs to be explained, and even in the civics classes, and everybody needs to understand that the arms of government are independent and co-equal. That needs to be something that is not negotiated. So that even when they come, if there is anything that requires negotiations, coordination, everybody coordinates only that which falls within their constitutionally prescribed sphere. So we just come to see, okay, what can we do about X, Y, and Z? This is what I'm going to do about it. This is what you're going to do about it. And this is going to be a doable. Without at the same time also compromising independence, because let's remember they're supposed to be also independent of each other, particularly the judiciary. You're not supposed to be making your decisions based on what the other arms of government are prepared to tell you. We will cooperate with you if you do this. Each of them is supposed to function independently. So that needs to be clear, that what is it that we are coordinating and to what end? But even then, nobody compromises their constitutional responsibilities in that process. That's how separation is meant to work. How can Parliament reclaim its distinct powers? I don't think it needs to be. I mean, it's Parliament which has ceded them. You just take them back. Just exercise those powers. But of course, I suspect also that linked to the other one, they may not be fully aware of them. They need to just do a proper reading of the Constitution and get themselves inducted. I don't know what the induction of members of Parliament when they're newly elected entails, but I think one of them should be a serious class on constitutional law generally, and then the role of Parliament within it. If that was done, then they would realize that they don't need to do this, because they find themselves being railroaded too easily by the executive. I am one person who still finds, in light of this, let me just divert a bit. I still find it very interesting when you're told that legislation first goes to cabinet for approval before it's presented. That's not something that's supposed to be happening. The lawmaking role is specifically in Parliament, except those where the Constitution allows the executive to instigate, such as budgets and the budget policy statement. And even then, the appropriation bills, etc., are negotiated first with Parliament for its approval. So it's just that they are the ones who've ceded the role. They just need to exercise their functions and do it, and everybody else will fall in line. Those should be my answers. Thank you.
Okay, thanks a lot, Sekou. So now we'll go to Waikwa. Waikwa, in addition to answering the 3 questions that I asked Sekou, there's a request for you to make reference. I mean, rather to state the titles of the 2 books that you referenced in your presentation. So go ahead.
Thanks, Kwame. So just on the titles, first of all, I think I talked about the fourth arm of government. I think that the title is the new 4th branch. Institutions for Protecting Constitutional Democracy, and it's written by Mark Tushnet. Tushnet is Tushnet, just in case people are looking for that. And the other book is How Democracies Die, and that is written by Steve Levitsky and Daniel Ziblatt. I'm just gonna try and pull the spelling for the last name, because I know people may want to Google this, and I can send this information to Jacqueline for those interested. So last name Steve Steve Levitsky. It's Levitsky, and the other writer is Ziblatt, Ziblett, and the title is How Democracy Die. So just to the question, if I may start with Leo's question on Parliament, and I agree with Sekou, it's really just taking the power they have. They have the power, it's there in the Constitution, they just have to exercise. But I actually think there's very little understanding by parliamentarians of what power they have. And then the few people who understand are quite invested and very crafty to know how to play that. And they're not interested or don't interpret it from a national interest level. I've always thought if Kenyan want the most consequential job in terms of governance, the job to go for is the Speaker of National Assembly, not even the President, not, for example, the Chief Justice. So if you think about the Chief Justice, you're restrained because judges will go and make their own decisions, and there's hardly anything you can do about that. If you think about the President, the judiciary is always coming hard on you. Legislature can change a lot of things. But I think actually a good speaker who understands how power works and who has some clarity of purpose can actually wield significant amount of power. And I was even surprised when on BBI that the emphasis was on, for example, Prime Minister's position and such, which are much more ceremonial positions, and without, when you think about it, substantive power. So my response would be, first, the starting point, you have to get the right person as speaker who fully understands and who is able to guide parliamentarians. A lot of our parliamentarians may not even have read the Constitution, even the parts that are controlling in Parliament. So you need somebody who really understands that, who is quite sophisticated about how power works. And just to give an example, the budget making process, and before I give that example, maybe my second way, you need to make or to bring a lot of professionalism in Parliament, make sure you have a lot of technical people. And I have to confess, I actually think Parliament does have fairly good technical people. For lawyers, for example, the ones I interact with, I actually think some of our best public office lawyers are in Parliament, unlike, I don't think as highly about AG's office, but I actually think quite highly about lawyers who are in Parliament. So, but you need to have leaders who are able to guide that technical knowledge. And just to give an example, in the budget making process, Parliament has so much power when it comes to budget making and allocation of resources. But what do we see in practice? Parliament just cedes that to the executive, the Treasury overruns everyone, and the only interest Parliament seems to have is largely on their own budget. But beyond that, they don't seem to be focused enough to know how other aspects of budget allocation actually influence how the state is run. So Parliament just needs to pull up its socks, in my view, and it has to start with the Speaker of the National Assembly. To your question, Kwame, and I want to combine my response to your two questions about coordination of functions and government being referenced only to mean executive. I just want to give an anecdote here. I participated in the litigation on Huduma number. And I was cross-examining the Principal Secretary of ICT. I think his name is Jerome Cheng. And I asked him the question, Huduma number in law is National Integrated Identity Systems, NIMS. That's why they call it NIMS. I asked him the question, how did you move from NIMS, National Integrated Identity Systems, and translated that into Swahili to Huduma number? And he was very honest. He just said, Huduma number is a communication concept. Why did I bring that anecdote? Because we sometimes don't appreciate the level of psychological conditioning that those people who are savvy or shrewd rather in government actually put on us. So when you use the term coordinating government and the Chief Justice buys into it and thinks that government should be coordinated and judiciary should be coordinated, what's the psychological condition that you're getting into? Who is coordinating you? And what are you communicating in terms of power balance? And what does that do when you send your officer who is to be coordinated and they are speaking to an officer who is coordinating them? And this also brings me to the reason why the president is so insistent on executive order. Why does the president have to keep doing these executive order and publicizing them and sort of drawing a sketch of what he calls organs of government and puts everybody there, even institutions that are not fitting? Is it because they don't understand that that's not what the law provides? No, it's because they're creating psychological conditioning. It's the same thing with of a reference of government as the executive. It's psychological conditioning. And it's good you raise this, Kwame, because I think as professionals, we really end up doing a lot of disservice to the people by sort of parroting these ideas and continuing to talk about government as synonymous to executive. And when we talk about, for example, devolution, we talk about central government as opposed to national government. Which is another conditioning term. So I think it's important to pay attention to this, and I thank you for raising that. It may sound trivial, but actually it's also important in governance, in my own view. Thank you.
All right. Thanks a lot, Waiko and Seku. We seem not to have other questions, so I am anxious to end this. So as you both promised, we'll have, I think, the references that you provided for us and the references that you provided for us and the presentation will be circulated. And I hope everybody who's seated here has learned quite a bit. So I'll ask each of you to make any final comments that you have. Again, this time I'll start with Seku. Seku, please make any final comments that you have, and then we'll come to Waiko as well before I close.
I don't have any further comments. Just thank you for this. Thank you.
All right, Waiko.
Yeah, I'll just say one thing, and this sort of has become the thing I say in every forum. When you look at the Constitution, there is so much potential of what we could become, and one of those areas is really understanding separation of power and the potential that lies there, especially in the context of the topic today, in terms of separation of powers and economic development, what the country could achieve if things are done right. Our problem, I think, is professionalism. We really underestimate professionalism. And I think a lot of participants here are professionals. We really seem not to value the prestige. When I'm an advocate, what does that mean as a professional in terms of the intrinsic value to me? And why should I not agree to doing or to supporting certain notions? Because that actually, it goes against what makes me intrinsically a professional. If we can get our professionalism right, and that goes all the way to the president, whether it's speakers, whether it's judges, if we can just be honest when it comes to professionalism, I think we can fix a lot. because we have the legal tool, and I think we have other tools that we can utilize, which is not a privilege that a lot of the countries have. But I thank you, Kwame, Jacqueline, and colleagues for the invitation.
All right. Thank you very much. So let me finish with 3 points. I think the first one is that our commitment at the Institute of Economic Affairs to expand discussions, but I mean, use discussions such as these to expand public understanding of the architecture of the Constitution, and not just the slogans that people cite, even we, regarding the Constitution, is a commitment we have for the long term. So for those who are seated here, I thank my guests, our guests quite a bit for helping to expand that, and we hope this is one part of the small building blocks towards that greater constitutional literacy. We think it's just as important, to be honest, as literacy in the economy, which is often based on convenient myths, but sometimes when you look at it, it's too superficial. So our view is that we really need to raise. It'll help with a better civic culture if part of it is to understand the Constitution. So that's the first. I also agree that one of the things that separation of powers does, both speakers stated, is basically whatever constitutional order comes in tends to abhor monopoly of power, or at least requires that separation of power through divisions, whether you call it division or separation. Of course, and we've learned today that there's a distinction between those two. It's important that specific institutions that are granted or specific bodies that are granted powers to perform certain functions in the Constitution, that order be respected, and it's something that we as citizens, but also as active people, do defend. So the idea that the power should be concentrated in the executive, or that the executive tries to condition us psychologically by referring to government as if government is basically the executive in a hill, and then the rest of them are just performing auxiliary functions, is one that we actually must consciously try to purge this country of. So that's a second part of it. The third one is in the separation of powers game, the institution that has done the poorest. And how do I assess that? I mean, you see every day, or rather so regularly, a lot of opinion polls in Kenya. And invariably they suggest that the judiciary has the highest. Well, it had it higher when, I mean, and this is not a point against anyone, but it was much, much higher. Approval ratings for the judiciary was much, much higher when the Justice Maraga was there. It's still among the highest of them at about 68. It was, I think, about 74 during Justice Maraga's time. The presidency at about 22 or 23, and parliament at some, following very tightly with a 9% approval rating, between 9 and 11. Sometimes it goes as high as 13 or 14. And so whatever you make of that, it's telling you that Kenyans do not feel that Parliament does a good job. And part of that might have been also, of course, the conditioning that happens. But more importantly as well is that I think Parliament has not exhausted its powers for the public good that the Constitution has granted. So part of this work is to ensure that that happens, to raise the professionalism of Parliament, but also the professionalism of the people who sit outside, as Waiko called for it, that we can create this public education, but generate knowledge in a way that we use not just to confront power grabs that happen, because in my view, power grabs are ever going to happen, it's going to come from the executive invariably. Kenya's Parliament is far too obsessed. Once it gets its budget approvals, obviously it goes into the sunset for another 1 year until the budget's done. But we think that one of the areas in which it has powers and where those powers should be applied is basically in budget making, because financing the state and holding the purse of the republic is one of the ways in which Parliament could actually restore balance and balance and republican order in this country. So I'd like to thank you all. We'll continue to think about it. If you have any questions, enduring questions about today's presentation or other areas of the Constitution that you'd like for the IEA to expand to, we would like to do that. As I finish, for us, it's not just to understand the Constitution in terms of its requirements, but also to understand principles such as separation of powers instrumentalized into, say, creation of economic empowerment, but also defending people's rights. So how does an instrumentalized division of separation of powers, which is a concept, work in a way that facilitates economic development? And I like the fact that Sekou mentioned that Sekou mentioned that one of the things that's most important about separation of powers is that the separation of powers argument is so important for us to make, because again, psychological conditioning comes in to tell us that economic development or development, human development in general, must be ceded, or some of the rights that the Constitution has granted must be ceded, and in order to achieve high growth. And pushing back against those arguments, they're not going to stop. Pushing back against that argument is the internal vigilance that you and I need to keep. So I thank Waiko again, and Sekou, thanks for giving us and to letting us your time, and for the 30 or 38 guests who are here to listen to this. We hope this has been worth your while. I'd also like to thank my two colleagues, Jackie Kagume and Leo Kemboi, who planned and have executed this meeting. So, ladies and gentlemen, thanks again for sitting with us for 2 hours and a bit. We'll let you know when our 31st webinar is held, and as soon as this happens, we'll have these presentations edited, and we'll have them on our YouTube pages. A link will be sent to you, and we hope you can use it for further meditation and actually to understand a little bit more. Thanks a lot, and have a good afternoon.